Kevin Hanley here. In this video, we're going to talk about how you start the bankruptcy process. Let's say you are experiencing financial difficulties. What should you be doing? You should start by doing a little self-analysis. Can you cut back on unnecessary expenses? Can you earn more income with a part-time job? Can you consolidate debt at a lower interest rate? Will creditors be willing to work with you to restructure your debt? While you are considering your alternatives, it would not hurt to consult with an experienced bankruptcy attorney to review your options. In New Jersey, most bankruptcy attorneys offer a free consultation. How do you make the most out of your consultation? You should put together information concerning your assets and liabilities and your monthly income and expenses. If you have been sued or if your wages have been garnished, you should inform the attorney and bring your paperwork to the consultation. In your consultation, the attorney should explain the alternatives to bankruptcy, the general process of bankruptcy, the basics of Chapter 7 and Chapter 13, and give you ballpark figures on cost. In Northern New Jersey, attorneys charge a flat fee for basic Chapter 7 work and an hourly fee for additional work. Additional work can include extended trustee investigations, lawsuits brought by the trustee or creditors, and certain motions brought by the debtor. In Chapter 13, in New Jersey, the attorney is entitled to what is called a no-look fee in the amount of $4,750. No-look means that the attorney does not have to file a fee application with the court. The court also allows additional compensation for a mortgage modification or for litigation. In the alternative, the attorney can charge on an hourly basis but must file a fee application with the court. For Chapter 7, the filing fee is $335. For Chapter 13, the filing fee is $310. In addition, you must take 2 classes which cost approximately $75. Most attorneys will require a credit report and a judgment search. Finally, if you own your home, the trustee usually will request a broker's opinion letter, which can range from $75 to $150. If you decide to go forward, you should expect that your attorney will provide to you a written retainer letter, which explains what the attorney will do and what you will pay for it. Once you retain an attorney, you will be required to provide a substantial amount of information and backup documentation relating to your assets and liabilities, income and expenses. When the lawyer gets all the information and documentation, then he or she can put together your bankruptcy filing. You must sign your bankruptcy petition under penalty of perjury. So you should take this process very seriously, because the United States trustee can and does make criminal referrals to the United States Attorney for bankruptcy fraud. The bankruptcy petition is now filed electronically. When the petition is filed, the automatic stay goes into effect. To sum up, you should take advantage of the free consult. If you and your attorney believe that bankruptcy is the right approach, you should enter into a written retainer letter. You should assemble all information and documentation for your attorney in a timely manner. Thank you for viewing our video. I'll see you in our next episode, The Means Test.